much. I first of all want to thank you for organizing this conversation. And let me start by saying that I appreciate what has gone before me, and I think my task is to talk about how the appointment of judges, or the process of appointment of judges determines their independence, effectiveness, accountability, and the legitimacy of the judiciary. And I want to commence my intervention with a cynical statement made in 1966 by Ugandan lawyer and scholar Dan Wadada Nabudere. He went with the Lord in the year 2011. And he was responding to what was happening in Uganda at that time. And a young lawyer trained in the Soviet Union called Picho Ali had said something, and this is what Dan Wadada Nabudere said, that when all is said and done, I agree, and we all must agree with Picho Ali, that there is nothing like independence of the judiciary, that the so-called independence of the judiciary is nothing but division of labor. And I think there is a sense in which there is cynicism in that statement, but he meant it because at that time what was happening in Uganda was that the administration of Apollo Milton Obote had dismissed some ministers, and they were arrested, and they appeared to be kowtowing to the executive position, which begs the question, is it true that the manner in which judges are appointed in and of itself makes them have probity, ability, independence, and resilience? Debatable. Debatable because, as I think it is Lord Atkin who said at one time, that he views with apprehension judges who, on a mere matter of interpretation, when face to face with the executive, become more executive-minded than the executive. Of course, in many countries, we now have processes where you have the Judicial Service Commission, you have public participation, you have all these methods, and they have come about because it is assumed that when those processes are that elaborate, so that a prospective judge, for example, applies for the job, that judge is subjected to public scrutiny, is interviewed, and then appointed, so that the role of presidents in many countries now is almost that of rubber stamping the process. Then it is assumed that the judiciary will be more independent. But let us talk about independence. What kind of independence? There is what one may describe as institutional independence. And I think most judiciaries in Africa, even in the weakest of countries, do enjoy some modicum of institutional independence, which must be seen in the context of financial autonomy, so that they get their funding directly from the exchequer. I think that exists at least on paper. And then, of course, there is the concept of personal independence, the judge himself or herself. It is true that judges are part of our society, and I've never believed for one moment, for example, that the mere fact that one is a law graduate removes him or her from the experiences that they have had. And there are people who are prejudiced. There are certain prejudices that people hold, but it's assumed that even when they are confronted with facts and they are confronted with the law, they will be independent. And I do believe that if people are independent, appointed through a merit-based process, then holding all factors constant, then they are more likely to enjoy personal independence when they are discharging their duties. The third thing is judicial neutrality. Neutrality is simply, in my understanding, means that the judge will be moved by nothing else other than the facts and the law. And once again, I want to say that these new methods of appointment, and I'm using the word new very guardedly, because in a country like Kenya, and indeed many countries, we are coming from a tradition where the president would simply appoint somebody, either because chiefs from his or her tribe had gone to see him and they said that their tribe was not properly represented in the judiciary. So you had such people, I know many of them in Kenya, people who had no idea what the law was, but they were appointed by judges in order to fill these ethnic equations. So there is a sense in which that is important. Judicial accountability. The public is there, and therefore there is a sense in which accountability also arises, particularly when they are answerable to the people's representatives in parliament. And we do now in a number of countries also have the Judicial Service Commission, which is constantly there and receiving complaints. And the restraints of the judicial power, there are rules which are critical. So in a nutshell, this is a subject which ought to be taught for 98 hours. I've only 5-10 minutes. So let me conclude by saying that I hold the view that appointment processes that are more transparent, that are merit-based, do serve to energize the judiciary in terms of imbuing the judicial officers with a modicum of independence and authority, as opposed to opaque systems of appointment which are based on the whims of the executive. Let me conclude there, because time is not on my side. Thank you.